Hello there, and welcome to another episode of Taking the Stand, a Freedom Advocacy Network podcast production, where we try to get you behind the story of some of the legal stuff, some of the law work that we do that might be going on in the country, in an attempt to really remind South Africans that the law should be about their freedom, and where it isn't, that should change. And I'm very, very excited about the development FAN is showing, building its capacity slowly but surely, getting to a point where we can really reach out to people and start making a difference. And it's about that we actually want to chat a bit today. And I'm joined, of course, as ever, by Ben Kun, the brains of the outfit. I mean, if he's the brains, I'm not quite sure what I am. I'm definitely not the looks, but I can try my best. Ben, thank you for joining me and bringing some actual substance to today's discussion.
How's it, Hermann? How's it, everyone at home?
Excellent. All right. So today, Ben and I are actually going to tackle a topic a bit differently from what we usually do. We're going to look at legal strategy a bit, in the sense that we're not necessarily going to look at specific actions. We'll get back to those next week. We've got a few beautiful ones rolling in the background. But today we're going to talk about what we like to call issue narrative litigation. Now, perhaps a brief introduction on that point. It's not a highly technical term. It's something we made up to internally describe what we do. The Fan Justice Project has two main purposes, two main project drivers of activity. On the one side, we've got our watchdog work, and on the other side, we've got our issue narrative work. And the issue narrative work is a bit of a longer term investment, a bit of a slower thing, but something that I'm quite excited to get started. And I think we're within a few days of actually getting this show on the road. What is an issue narrative case? Well, it is where we learn from our American colleagues and we start understanding that if you can go beyond the principle at stake and you can show a real human being affected by the principle at stake. You can follow what Anthea Jeffrey over at the IRR calls the PhD factor: personalize, humanize, dramatize. If you can harness all these things, then you get court cases like that of David Akase, where an individual citizen became a symbol for a principle of vital importance. And today we're going to delve a bit into that. Ben, if I say to you, issue narrative vehicle case, tell a story, make it real, what does your mind go to immediately?
So I think the most salient sort of case that stands out for me with regards to issue narrative is the Roe v. Wade case from America. And that's a very famous case, very controversial. It's the abortion case. So basically, what happened is in 1969, Paula McCorvey fell pregnant and she wanted an abortion in the state of Texas. And the only chance you could get an abortion in the state of Texas was if you were raped or if it was incest. So she ended up not being able to argue if it was rape, and she incidentally had the baby. But so she actually no longer had an interest in the case, really, because she'd already had her child. But because it was such a sort of vital freedom for women to choose whether they wanted to have an abortion or not, there was so much public interest and also medical interest from doctors. And this case ended up being brought to the US Supreme Court in 1973, years later, after she'd already had her baby. And basically, it's actually, upon doing a bit of research for this case, I found out that the worst joke in legal history came from it, where the attorney for the state said in his opening arguments. Oh, it's an old joke, but when a man is arguing against two beautiful women like this, it's always he who has the last word. And that joke did not go down well in the court.
Yes,
so the
understandably
judge,
so.
But basically, the judge in the matter looked into why would the state have an interest in this case? Why is it their interest to not allow women to have the freedom to choose? And there was 2 points. The one is the woman's safety, and the other is the viability of the fetus. Is the fetus a person or not? And he broke it down into trimesters. So he said in the first trimester, there's actually no danger to the woman. So why there's no interest for the state to get involved here? It should be the woman's right to choose. The fetus is also not viable in the first trimester. So it's not, the state has no interest to get involved. And it's actually a privacy matter and a freedom matter, and that the woman shouldn't be allowed to choose whether she wants to go through it or not.
I must say, I think Roe v. Wade is one of the worst judgments ever written. It is up there with Obergefell as just utter constitutional malpractice. Because I think the law is bad. I think Justice Blackmun just invented constitutional theory out of thin air. But the thing I actually want to get back to, I don't want to get into an abortion debate, which can keep us busy for a very, very long time and has good liberal arguments to be against. I want to get back to the nature of an issue narrative case, because as you lay it out there, it's clear that legal principles, these exact things that you have now alluded to and that the court used to determine the law for decades beyond that, was an individual's life experience, lived experience, if you wish. It wasn't just cold clinical law. And we see that, I think, also in cases like David Rakase, more locally, it's a good opportunity to show the court and to show the public that these aren't just abstractions of theory. Real lives, real issues are at stake.
Yes, 100%. And if we're able to do that at FAN and to see someone whose individual interests, rights, freedoms have been affected, and we can make those arguments and turn them into good law that will enhance the freedom of the society as a whole, that is really our goal with an interest narrative approach to legal work, rather than just watchdog approach where we see, oh no, the government has done something wrong here, we need to write them a letter, perhaps threaten with litigation. This is a completely different avenue to take, and something that I think can really be beneficial to us and to the society as a whole.
And what's really exciting for me about this is it's not really being done in South Africa currently, not deliberately. You get these cases of Mr. Rakase or perhaps the Obo Barnard case, and they become, to law students, at least like you and me, they become these sort of cases that you remember because they affect fundamental aspects of human nature. And I remember from my LLB studies is that when you are intrigued, when you are invested in the factual, it's real life circumstances of the applicant or the defendant or the plaintiff or the accused, the law comes alive. The law becomes something different. That's why I never liked private law, because I feel it's just rules that you have to adhere to or not. But when you look at actual liberties being at stake, and of course private law goes into that, but if there's a story to tell, it makes a difference. And perhaps a last question to you, and this might be a bit of a curveball, but I think you'll be more than fine on that, is people often think that the law, and especially the courts and judges, are some sort of calculator. You put in numbers, you put in, multiplication or minus, plus, minus, or squaring or cubing or whatever you want to do, and you hit a button and you get a result, that it's this clinical, purely intellectual idea. Do you think that there is actually some chance that FAN might start something great here, where we no longer treat the law as a pure abstraction, nor the courts as something disconnected from broader, societal thinking, and we actually realize that on the other side of this bench, there's a human being that might, if we convince them to care about the individual, our client, might think, I can do justice here by changing the law? Or am I being very idealistic and naive here?
There was a lot there, but it's very optimistic, but it's not impossible, and we've seen that in the past with the law. There's a lot of value judgments that go into making these kind of decisions, and that is done through good argumentation and good presentation, and like you said, personalize, humanize, dramatize, and that is really what we are going to do in trying to push forward our ideals and what we think.
Oh, I'm genuinely, like, I'm so excited for this project to get started, and I can't wait to keep our audience updated and our followers and our supporters updated about the progress, about finding these individuals that can become banner carriers for liberty, for real freedom, for real progress. Because a year ago, I spoke on the phone to David Rakase. It was the day of him hearing essentially that he would be victorious. And I gave him a call, and it left such a mark on me to speak to this man who had become, for so many, at least in people invested in this, something of a symbol, a banner carrier for people to rally around. And I remember asking him, so Mr. Rakase, how does it feel? And he says he's never felt stronger. And I think when we look at what FAN is trying to do, it's about empowering, it's about building, and it's about connecting. So I really hope that these issue narrative cases, as we hunt for them, as we find them, as we share them with you, our audience, they can help us echo the words of Mr. David Rakase, where we say, we've never felt stronger. I think that's all we've got time for. I got a bit emotional and poetical there at the end, but us lawyers do have hearts. Well, the research is still ongoing, or as we might say, the jury is out. But on that note, Ben, thank you very much for this brief discussion. It's about this very, very exciting development where we can make sure that the law is about your freedom. And as ever, well, you know the drill. Your freedom is worth fighting for. Thank you very much, and see you next week.
Cheers.